for a seller who is just starting up, should they register for trademark or patent?
And so it really depends on what you're using for your branding.
And you mentioned about the color, right, on the patent side. So this is kind of a bit tricky.
So you get those different options depending on the type of intellectual property that they are infringing.
And for Amazon sellers, what type of services that you offer in terms of trademark, copyrights, and patents?
Ecom Squeezed podcast.
Welcome back to another episode of Ecom Squeezed. I am your host, Sebastian, founder of Retail-Outsource. And today we are discussing something that every business owner thinks that they understand, but probably doesn't. I'm talking about trademarks, patents, copyrights, etc., and how to legally protect your brand before someone else does. To help us navigate this legal maze, we have got a powerhouse guest, Jeff Holman. Jeff is an intellectual property attorney who specializes in helping startups and businesses safeguard their brands. He is also the founder of Intellectual Strategies, a law firm that provides fractional legal teams. Basically, a way for business to get top-notch legal advice without hiring a full legal department. Jeff, welcome to the show.
It's my pleasure to be here, Sebastian. Thanks so much for having me.
Great. Could you just give us, I've mentioned a lot of things, but could you just explain your background? I saw one of your episodes, you were kind of engineer before.
Yeah.
And,
Yeah, I'm happy to go through that. I'll be brief though, because it's been a long path to get where I'm at. So I did start out studying electrical engineering. That kind of put me in a good position eventually to get into patent law, become a patent attorney. So I spent the first 10 years of my legal career really working with innovators, right? People creating something at big companies that like IBM that ended up being small pieces and just various ideas that they were trying to protect to put into their portfolio. On the other end of the spectrum, when I worked with startups, I found that I was really working with the key piece of technology or the key product that startup was trying to launch and grow their business around. So I kind of fell in love with that, right? It's fun to be in the central part of the business, especially where the thing that they're building their business around. So as I did that, I went and my path kind of went to go get an MBA so I could be more valuable to my clients and speak the broader business language in addition to the legal and the patent and the engineering language. And that's brought me to where I'm at today, really trying to build a firm that caters to clients, mostly in e-commerce and SaaS, that is focused around innovation and bringing new products to market and helping people protect from an intellectual property standpoint, as well as a broader legal standpoint, protect their ability to grow that company over time into something successful.
Great. That's a lot of story behind you. And in today's episode, I want to ask the question mainly from an Amazon seller point of view. So my first question will be, for a seller who is just starting up, should they register for trademark or patent? So, if they want to register, why it's so important?
Yeah, I'll distinguish between two cases, right? If somebody is just going out and buying product and then turning around and selling it for arbitrage, it's not their product. Trademarks probably are less important for them. If you're buying and rebranding a product, or if you're creating your own product, then trademarks are extremely important. And the answer is definitely yes, you should get a trademark on that. There's sometimes ways to stage how quickly you jump into the trademark process, but you should definitely at least take the initial steps early on to get started and pointed in the right direction.
Great. And what are the risks of not having the trademark, for your product, for example?
Well, the most immediate risk on Amazon, for example, is not being able to get into brand registry, right? You want to be in the brand registry so you can easily enforce your product. The trademark it doesn't have to be granted, but having a trademark filing or registration is just a foundational piece to getting into brand registry. That's the first one. The second one is, people, it's interesting because I work with so many people who are building their dreams. In essence, they're like, I'm launching this business, I'm creating something from nothing. It's amazing. But if you're creating something from nothing, when you create something from nothing, you might as well create the brand that you're going to eventually maybe use to sell your business. Because companies that have a brand, have a registered trademark, statistically just become worth more money. They sell for more money eventually because that trademark is part of the business. So I think it's very important from a logistical standpoint, I'll call it, to be in brand registry, but it's also very important to actually put that piece in place for your brand value long term.
And when we first register for a trademark on the government website, for example, they always ask you, is that a word that you want to register, or is that the logo, right? So could you explain between, what's the difference and what should seller focus on? Is that the word, or should they focus on logo, or both?
Yeah, ideally, over time, you'll build up a relatively big trademark portfolio to protect your product and your branding from multiple aspects. That might be words, logos, trade dress even. Some companies go so far as smells and colors and sounds, although that's a lot more rare for those types of things. But the difference between a word mark and I'm going to call it a design mark, because in the US that's what we would call it. So a word mark is really the word alone. No colors, no fonts, no stylization, no graphics. It's just the word. That's really the broadest form of protection for trademarks, is if your brand is a word, because you're not limited to somebody infringing that only if they use the same color, only if they use a similar font, right? You get protection for the word regardless of the colors, fonts, graphics that are put with that word. So it's really the broadest form for a lot of brands to start with, if that's available. The logo mark or the design mark is some type of design. It might incorporate words, or it might not. It might be just a logo without words. And so it really depends on what you're using for your branding. If you're using a word for your branding, which I would highly recommend doing, you might as well put that as one layer in your trademark portfolio, that word, that custom or unique word that describes your product. And then if you also have a logo, especially if that logo is different and unique and very identifiable, you should protect the logo additionally. So in a scenario where somebody has a word that is a word mark, but they're also using that same word kind of by itself, but with some stylization as their logo, I would probably just go for the word mark without the stylization. But if you have a word and then you also have graphics or some other branding element that's not necessarily just your word, then you might want to consider filing for both of those up front. Or at least at a minimum, do some searching to understand if you're going to run into problems when you eventually do file.
Great. And, I hear a lot of sellers doing it, doing the trademark application or patent application like DIY themselves. What are the danger of those actions if they do it by themselves?
Well, there are different dangers for trademarks and patents. I actually put together a full course on DIY provisional patent applications. Anybody could go to my website, look at my blog. I've got like 35 videos or something like that, all set out. Now, it's a little dated because the USPTO has changed their filing system, the actual interface you use to file it, but all of the data in there is really good. But it's really hard to do right. That being said, I did that because a lot of inventors have the ability to describe their invention enough that they could file and get patent pending status using a provisional patent application and be okay. That product is likely to change and develop over time anyways, and you can't add into that same provisional, but you'll file your non-provisional or a second provisional to capture those changes over time. So there's a way to kind of, if you will, build on a provisional patent application and sort of effectively cover the development process of your product. Trademarks, though, are different. There's no real way to put any material changes into your trademark application after you file. So we usually see one of two things when we run into a DIY trademark applicant. One, they've got a really simple word or logo. They've got a really simple product. It's very standard type of product, so that there's some type of existing what we call description of goods and services already suggested on the trademark application filing process. And they'll move through that, assuming they've chosen the right trademark, and we could talk about how to choose a trademark. If they've chosen the right trademark to pass the test that the trademark office is going to do, then the filing process can be very simple. That's about half of the people that do a DIY. The other half, what we find is they do some of the process wrong, and they just don't know it's wrong until they get 9 or 12 months into the process. An examining attorney at the trademark office says, hey, by the way, you need to change this, or this doesn't look right, or you're in the wrong class. At that point, there's no way to fix it. So oftentimes we'll see those people come to us and they'll say, hey, I got this office action. It says these things. And I'm like, yes, you did it incorrectly and you have to start over. So you lost the time, which is probably the most important part of the process, but you also lost any effort that you did, and you still ended up having to pay somebody to do it. Again, I would say the best thing to do for trademarks, even if you're planning to file it yourself, just to have a quick conversation with somebody who knows the process, because they can tell you what the filing process is. They can tell you about the different type of distinctiveness levels that there are. So you pick a more distinctive or a less distinctive trademark on purpose. And they could talk to you about likelihood of confusion, which is whether or not your mark is similar to other marks in the same category. Those are the three things. If you know how to do those three things, it's pretty easy. If you don't, it's also pretty easy, but you probably screwed it up.
I completely agree with you. I heard a horror story from one of my friend who's a seller. He put the trademark in and the category that he have selected was the wrong one. So he only knew it after like a few years afterwards, basically, when he tried to enforce that law. It was on the wrong category, couldn't enforce it. And, I want to follow up on the trademark name. So for example, if I want to have a name in my mind, so I want to check, if somebody have it, is there any place that you can search it, not just for the US or, for worldwide, for example? Is there any website that you recommend for that?
Yeah, there are a lot of services. You can subscribe to some services and go look at it. What I would do if I was just starting out, was just from maybe a DIY mindset, right? I would go to the US website, uspto.gov. You can go to the trademark section, find how to search. They've just improved it recently. It's a very good process to search. Again, if you know what you're searching for, but they do a really good job pulling up a lot of potential results to help you see what's out there. If you want to go over and look at like the EPO or the European Patent Office website, you can do something similar there. So every country has their own systems. A lot of those systems are searchable. And what we'll do is, we actually have access to a service where we'll do this in a more streamlined fashion so that we can be quicker with it. But a DIY person could go to a couple of these places, look on the patent office websites for searching trademarks in the countries that they think that they're going to manufacture their product, sell their product, maybe transport their product, advertise their product, those types of things. Those are the countries you want to look in. And so that would probably get you good coverage, at least initially, to give you an idea of what's out there. The other thing you should do is you should go and just search online, right? You should say, because a lot of people don't necessarily register their trademarks for a variety of reasons. And somebody who's selling the same product under a similar name but hasn't registered their trademark could still be an obstacle to somebody trying to actually go through the trademark process officially.
Great, that's a great answer. Regarding, I want to move on to the patents now, the design patent, for example. Yeah. I had a scenario, I'm a seller as well. I got one of the patent claims, so it was for the shape rectangle. It was strange, after you can't patent a shape, right? But Amazon removed our listing basically. And we found out it was a Chinese seller. Basically, it need to be novel. Then we have to fight it, send the letter. The seller didn't respond. And we have to get a lawyer in place and contact the legal department to get it removed. But it was a long process, right? So in your experience, can you people, how can I say it, patent common things like, shape or a letter or something like that? Can they do that and enforce it?
Yeah. That's a great question. There's probably a lot of layers to it. So if I get too deep too quickly, just let me know.
Sure.
So you're talking specifically about design patents. So we want to distinguish that from utility patents. Design is really about the ornamental look, shape, style, the ornamental style of the device that you think is novel. And you think that ornamental style is novel compared to other things that are similar out there. So there are a lot of scenarios where people will apply for design patent protection for a piece, not the whole thing, but a piece of their device, right? This is really common in the automotive industry. It's common in fashion, shoes, things like that. But then also e-commerce. And I've got clients who we've specifically suggested consider not only filing for design patent protection, but maybe design your product so that you have a common design across multiple product SKUs that you can protect with one design patent, as again one layer in your IP protection. So with all that said, the test, what's interesting about design patents is the test for infringement of a design patent is much more similar to the test for infringement of a trademark than it is for the test of infringement for a utility patent. So it really comes down to likelihood of confusion. Would somebody look at your product, at the ornamental design of your product, and think that it is likely to confuse or substantially similar to an existing product that's out there. Now, if that existing product has a design patent on that, then they could potentially stop you just by showing that your design looks confusingly similar to their design that's already got a design patent. The patent and trademark office, when they examine these design patent applications, they do the same test. They say you applied for a design patent, or maybe you have like a little drawing tool, and it's got some swirls in it or something that you don't think anybody else is using those, and you say, well, I'd really like to protect that so nobody else uses my swirl design. And so they would look at that and say, is there any other product out there, either in our patent databases or, perhaps online? Is there any prior art that already shows a similar type of device with a similar type of swirl design? And so I like design patents because they're a lot easier to get, they're less expensive, and they're a little easier to enforce than utility. But they tend to be more narrow also because of this test for substantial similarity of the specific design that you've applied for.
Great. And you mentioned about the color, right, on the patent side. So this is kind of a tricky situation. For example, if a mouse, for example, can you patent the color of a mouse? Or is there any other reasoning? There should be other reasoning for it.
Most of the time, what you would probably see is people looking to trademark the color as opposed to patent the color, right? Because you're using that color as a brand indicator as opposed to perhaps a unique. I honestly haven't seen anybody do color in a design patent. It might be possible, but I don't know. I think you'd want to look at it and say, why am I doing color, right? Why am I creating a mouse that has this specific Pantone color combination, for example? And you're probably doing it so that it stands out and so people recognize it. And so you're really using that as a brand identifier at that point, more than, it might also be a unique design patent type of ornamental style, but the primary purpose would be trademark, brand identifier functionality. So I think most people we work with, at least, they would say, I want to use this as a brand identifier, so I'm going to go through the trademark process with the color. Layering on anything in the patent world, I'd have to look into that, to be honest, because I don't know that. I've never heard of somebody trying to patent the color of something, and I don't think it would go through. But,
yeah, true.
I could be wrong in some really limited instances.
Great. And I want to talk about the enforcing on Amazon. If your brand registered, you can enforce it on eBay. We can use Vero, right? So what if on a website, how can you enforce, hijackers or, fake sellers?
On an Amazon website or on like a Shopify website?
Yeah, on a Shopify, for example.
Well, if somebody there's a couple of things. It depends on where they're hosting their website, right? If they're hosting it through a platform like Shopify, you might be able to submit it through that platform. A lot of these platforms have a mechanism to submit potential infringements, and they'll do some kind of administrative, really high-level assessments and pull people down. Amazon's really good at that with brand registry, eBay, Etsy, things like that. When you have somebody on their own website, typically what you're going to do is you're going to ask for, well, it depends on what they're infringing. If they're infringing your trademark or your copyright or your patent, you're going to take different actions, right? If it's a copyright issue, then you can do what's called a DCMA takedown, and you can ask for the just generally the people who regulate websites to take that down, right? To take that website down, just shut it off because it's infringing copyrighted material. If it's a trademark or patent infringement, you're probably going to have to go through the traditional course of action of sending them a cease and desist letter, maybe suing them in court, and trying to track them down that way. You might also send notices to the domain host, depending on how they're running their website. But that's going to be so you've got those different options depending on the type of intellectual property that they are infringing.
And, most of the Amazon sellers, they sell internationally. For example, US sellers might sell in the Europe, all this Germany, France, UK. For those sellers, if they have one trademark in the US, is that sufficient, or should they have trademark in all those individual countries? This goes for the patents as well.
Yeah, patents and trademarks, they have different systems to essentially link to different countries together. So at a really fundamental level, if you have a U.S. patent or a U.S. trademark, you can only enforce that in the U.S. You could stop people from selling it in the U.S., making it in the U.S., importing it into the U.S., advertising it for sale in the US, but you really can't use that to stop anybody from making it in China or selling it in Europe or advertising it in South America or whatever that is. So you really, what they've done is there are several, you could go and apply for protection in each country individually if you wanted to, or there are several treaties and international agreements that several countries have entered into, so that you can essentially use one filing in one country to create a related filing in another country or in a region of countries, like you could file in Europe as a whole for a community trademark as opposed to individual countries, or maybe in addition to individual countries. So these international treaties and agreements, really, they don't let you enforce one mark from one country into other countries, but they make it possible to file related marks in other countries after you've already filed a mark in one country. What that really does is it gives people a little bit of a break with the timing for filing and paying the fees and doing all of that related IP, because IP is really based on priority. How soon you file for protection is a very important part of the strength of the protection that you'll have against infringers, because you only get protection against people coming after you, not the people before you. So it really is a way to give you to kind of link the applications together in different countries and allow you to preserve the priority from one country into those other countries.
And on Amazon, if you are brand registered on Amazon, you can use that trademark across to get A+ content and all those services on Amazon. But my question will be, can you enforce them? Can we report a fake seller or someone hijacking the listing, for example, selling fake goods? Let's take an example for the UK marketplace. Is there any way that we can enforce or remove that seller with the US patent or trademark?
That's a great question. I don't know the answer to that offhand, candidly. I don't think that the system I think you'd have to show some type of connection between what's happening overseas relative to the IP that you have in a specific country. If there's not a connection there, if there's not something happening, I don't think that they would take you down, because there's not really a legal remedy in that country if you don't have trademark rights in that country. So I don't believe that would happen. I don't believe they would help you enforce that without something in the specific country, or maybe a more, let's call it kind of interconnected showing that somehow what's happening in that country relates really directly to where your IP sits. But I don't think that's a strong position.
True.
For the IP holder in that case.
I bought a thermos cup, and on the labeling it was mentioned like trademark in 145 countries or something like that. It's strange to read that. So, big companies are doing that. I think small sellers should take a note of it. My next question, most of the sellers, they bring the manufacturer, the products back in China, right? And most of the horror cases is that at some point they will produce the same product, they will copy the design, and they will start selling directly to the US. So how can you take actions or prevent that happening?
That's a great question. And, hear about it happening on occasion. I don't think it happens all the time. Well, I think it happens quite a bit. There's a couple things that you have to do. One is your trademark protection. And you really should, if you're going to manufacture in China or wherever you're going to manufacture, you should consider filing for trademark protection in the country where you're going to manufacture so that you can enforce that. We've heard stories of people who have gone to China, started making their brand there. The manufacturer or a trading company then steps in, files for trademark protection for your brand in China, and then they hold you hostage because they say, well, you can't go make this somewhere else because we own the brand in China. So nobody else in China can make this except us. That would be a terrible situation. So trademark protection is one thing. The other thing that you're going to do is you really need to be careful about your agreements with your manufacturers, right? So the in agreement, non-circumvention, non-use type of agreements that you put in place with a manufacturer, hopefully, those would be the things that would be another layer of protection against somebody doing that type of that type of activity that they might end up infringing, or it might not, depending on where they're doing it. So in agreements are the other layer that I think are very critical to preventing or decreasing the likelihood of that situation.
And the next one is what Amazon neutral patent evaluation program, and how can sellers use it to fight copycats?
So, sorry, say that again.
It's the Amazon Neutral Patent Evaluation Program.
The Neutral Patent Evaluation Program. Well, I mean, like their programs, in our experience, you can submit trademark, copyrights, patents to Amazon to be evaluated for potential infringement by other people. We've had stories in the case of trademarks and copyrights. It's usually pretty quick and pretty easy for Amazon to make these decisions. Our experience has been that design patents and utility patents especially are a lot more difficult for Amazon to administer because it's difficult for them to make. There's a lot of legal analysis and a lot of legal conclusions that have to be made around patents, what they cover, because it's not just what the patent says. You actually will, if a patent's ever litigated, you go back and you look at what was said in the application process. Is there anything in the application process that changes what the patent means and the language that was used in the eventual issued patent? So there's a lot. We found that it's possible. Amazon is much more hesitant to give you an enforceable infringement position based on patents alone. I don't know if that answers your question or not. But
yes, it answers exactly. And let's put a scenario in this case. A competitor falsely claims that use their trademark or use their patent design. In that case, how you can fight back, basically. Amazon will take the listing down straight away, and they will only forward you the email of the seller who made that claim. So Amazon will step back and say, okay, you both fight. And so in that scenario, how do you manage it?
Well, so we have this happen with some of our clients regularly. And so there's an appeal process internally with Amazon, but then you probably don't want to rely on that by itself, because Amazon, they're not judges, they're not attorneys that are necessarily advocating for you. Even if they had attorneys that are looking at these things, nobody's advocating for you, and you really need an advocate. And so a lot of people will hire an attorney to help them through the appeal process, but then they'll also consider, outreach to the party claiming infringement so that you can establish, hopefully, a communication with them and see if there's a way to work this out. Is there truly infringement, or is it just a claim that's kind of distant and not a very strong claim? That's important. If there is infringement, how long has it been happening? Was there knowledge of the infringement? Is there the possibility to license out that technology, the brand or the patent technology, and establish a working relationship instead of just being shut down? So it gets very detailed and complex, and it depends a lot on personalities and feelings even. Does somebody feel like they've been cheated by somebody? They're less likely to allow somebody to concurrently use their trademark for their own products. So it really comes down to a negotiation activity with the parties claiming infringement. That's probably going to be more effective. Not that you're necessarily going to get the result you want, but I think you have a higher likelihood of getting the result you want doing that instead of just relying alone on an appeal process through Amazon.
And in that case, if it was not fruitful, for example, should you escalate it, or is that based on each cases and scenarios, the chances that you are winning, or how do you play around, or how do you escalate that to a court, for example, if you want to settle in court?
Yeah, it's a great question, and it is really case by case. First of all, you can file things in court like a declaratory judgment action to have the court say that maybe a patent is invalid. Maybe it wasn't validly granted, so it shouldn't be enforceable against you. Or you can say, even if it's valid, maybe you're not actually infringing and you want a determination from the courts that you're not infringing. You can do that. It's very expensive to do that, especially in the US, but it is possible. If you're going to do that, we would want to have a lot of consultation with a client first to make sure that this is a financially worthwhile investment for them on the legal side. And unfortunately, there are some cases where the claims of infringement aren't necessarily strong, but the costs to defend that and to take it through the whole process are just too great to really defend it well and to justify the defense. And so there are situations where you get some, we'll call them maybe bully IP owners, who know that just by making these assertions, they can take more people down, just because financially they could probably pressure them in a way that's not sustainable for the type of product or the quantity of product that they're selling.
Yeah, I can see that happening to a lot of small sellers. The bigger companies always, bully them around. I can see that happening.
Yeah, and that's why it's so important. We've had, it's fewer now. I think people have caught on to this, but I think there's some services out there that say, hey, here's some really hot products. And then people go jump on them. They're like, oh, great, I'm going to go sell this jewelry, or I'm going to sell this exercise equipment because it's selling so well. And you get a bunch of people jumping on, finding places to order it, not from the not from the main brand manufacturer, but another manufacturer, buy $100,000 of inventory and they go start selling it. And then all of a sudden the brand says, they see this and they go shut everybody down. People in that scenario haven't done their homework. They've done their homework to find a product that sells really well, but they haven't done their homework to find out if that's a product they can sell without infringing somebody else's IP. That's the side that is missing a lot of times, and it leads to a lot of heartbreak and a lot of financial losses if you're not careful with both the product and the IP.
My last question will be, you can purchase, patents and trademarks, right? So in that scenario, is there any specific area that you have to look into, the seller have to look into, or they have to consult with a specialist like yourself to get all those checks done?
So that you're talking specifically about buying IP directly from another party. So if
correct, yes.
Okay.
So for example, in that case, let's say we are buying out the full company and the patents and the trademarks will come with it. So in that scenario.
Yeah, so that's all part of the due diligence process in an acquisition of some sort, right? An asset acquisition or a company purchase. And so a lot of people, it depends on how detailed you want to be and how much the IP is driving that acquisition. So if you're buying a full company, it's operating and it's making good money and it happens to have some IP, you're probably going to look at the schedules. You're going to get a copy of the patents and trademarks, review them, but you may or may not do a full in-depth review of the history and the strength of those patents and trademarks. However, if your transaction is really buying a patent or a couple patents or a couple trademarks because you want the brand, then you might be, depending on the value of that transaction, you might put a little bit more effort into looking deeper into the IP because that is where all the value of the transaction stands. And if you haven't done your homework, the transaction might fail for different reasons. So certainly at a very minimum for any of these transactions, you're going to want a schedule of the IP. That should be very common. And you just say, hey, I need, give me your docket or give me your schedule of all the patents and trademarks that are owned here and which products they cover. And, if all the maintenance fees have been paid, if that's applicable in the countries that you're looking at and things like that. So it's going to be really kind of a list that you want to go through, at least at a first pass.
And, for Amazon sellers, what type of services that you offer in terms of trademark, copyrights, and patents?
Oh, that we offer? We're a little bit different type of law firm. We do patents, trademarks, and stuff like that. We actually have, as you mentioned at the beginning of the show, we have what we call a fractional legal team. So, a patent attorney. We actually have 2 patent attorneys. We have some trademark attorneys. And so we do those services either as a one-off transaction for people. A lot of people will come to us and just say, I need a trademark or I need a patent. And we'll walk through that process with people. And then other people will come and say, well, we need that, but we need kind of full legal advice, at least on a fractional basis. And so we'll step in and be their general counsel, look at a lot broader issues like maybe employment in their company or fundraising, investment dollars, stuff like that. So it really depends on the level of service that somebody wants. But we've designed our business very intentionally so that we can cover up to all the services that a seller needs. But it's really stemmed because of my background. It's really centered on who I call innovators, those people that are creating new brands and new inventions. And so most of our clients will come to us and they'll have some type of patent and trademark work that they want. And that will eventually lead into, us doing a broader set of corporate services and contracts and things like that.
Great. Yeah, that answers it. And for the viewers, where can they find you?
Yeah, I am in 2 places. One, I'm on LinkedIn quite a bit. Feel free to reach out to me there. Just look for Jeff Holman. It'll say something about fractional legal teams. That's a really big part of what I do. So you can find me there, send a connection request. Don't solicit me for stuff or I'll just not ignore you. But if it's a legitimate request, I'll accept. I really love connecting with people building things. And then the other place is through our website. We do a free 30-minute strategy call for potential clients. So people will call up. They'll tell us what kind of things they're working on, maybe the messes that they're in legally or the things they're trying to avoid, where they're headed over the next, 12 to 18 months. And we like to use that time to get to know somebody, but also start to plan out, well, if this is your roadmap for your company, what are the legal steps that should be on that roadmap to match up with your business steps? So that's a free strategy call, and people can access that from our website, intellectualstrategies.com. And see my calendar or Danielle's calendar directly and schedule an appointment.
And I think, I'm sure that a lot of businesses at some point they will need your help, right? At some point. So ideally they want to do that, initial call and, strategize the full planning at the starting itself. So it will be much easier later on. You don't have to wait to get some claims and stuff like that. And regarding the LinkedIn and the website, I will put the links down in the show notes. And thanks a lot, Jeff, for advising all this topic. I appreciate that.
Thanks for having me. It's been a great conversation with you, Sebastian.
Thanks, Jeff.